I've been in rooms where people sit across from each other and stop using names, where a daughter refers to her mother as the defendant, where brothers hire separate counsel and communicate only through assistants. It doesn't start that way. It starts with assumptions. Someone thinks they're understood. Someone believes their role is obvious. Someone assumes the house, the account, the business, the child's future is implicitly theirs because they've always acted like it was. Then someone dies, or divorces, or sells, and the assumptions become liabilities. I've sat across from people who say the same thing in different words. We never wrote it down because we trusted each other. We talked about it once, maybe twice, but it was clear. I thought we had an understanding. Understandings are not enforceable. Memories are not evidence. Goodwill is not a contract. People think documentation is for strangers. It's not. It's for when the people you know become people you're suing. Most of my cases don't involve strangers. They involve siblings, spouses, business partners who have known each other since college, parents and children, people who shared holidays, weddings, hospital rooms. Then one conversation goes wrong, or one decision gets made without consultation, or one person finds out they were left out of something they thought they were part of. And the relationship ends. Not slowly, instantly. What replaces it is a file. I've watched this happen more than 200 times. The patterns are consistent. Someone waits too long to speak. Someone assumes silence means agreement. Someone signs something they didn't read because it felt awkward to ask questions. Someone lets years pass without updating documents because it seemed unnecessary. Then circumstances shift. A second marriage, a medical diagnosis, a liquidity event, a remarriage of a parent with young children from the new spouse. And suddenly, the old paperwork doesn't reflect current reality. But it's still binding. People don't understand that the law doesn't care about fairness. It cares about what's written. A will from 19 years ago that names an ex-spouse as executor is still enforceable if it was never revised. A partnership agreement that gives equal control to 3 people stays in effect even after one of them stops contributing. A trust that made sense when children were young becomes a cage when they're 40. I've seen families dissolve over amounts that wouldn't buy a car. It's never about the money. It's about who was trusted and who wasn't, who was included and who was erased, who knew and who was left in the dark. The dollar value is just the language the fight happens in. One case involved 3 sisters. The mother had dementia. One sister had power of attorney. The other 2 suspected misuse of funds. By the time I was brought in, they'd stopped speaking. The sister with authority had moved money. Not stolen it. Moved it into accounts she controlled to protect it, she said. Totally legal under the document. Totally devastating to the family. Because no one had asked the others first. The power of attorney document was 30 years old. It gave complete discretion. The mother had signed it when all 3 daughters were in college and got along. No one revisited it. No one updated it when relationships changed. The 2 sisters sued. They lost. The document was clear. They haven't spoken since. Another case involved a father and 2 sons. The father owned a commercial building. For 15 years, one son managed it. Collected rent, handled repairs, kept the tenants happy. He assumed the building would eventually be his. It was never discussed. The father died. The will split everything 50-50. The son who'd managed the property for 15 years got half. The son who'd never set foot in the building got half. The managing son tried to argue sweat equity, tried to argue implicit agreement, tried to argue his brother should have known. None of it mattered. There was no documentation, no employment agreement, no succession plan, just assumptions. They sold the building and divided the proceeds. They don't speak either. I made a version of this mistake myself once. I loaned money to someone I'd known for 18 years. We agreed on terms verbally. I didn't draft a note. It felt transactional to formalize it. When repayment didn't come, I had no leverage. I never saw the money again. I didn't sue, but I learned. People treat legal structures like they're for corporations or the very wealthy. They're not. They're for anyone who wants their intentions to survive their presence. A buy-sell agreement isn't paranoia. It's a pre-decision made when everyone's rational. A post-nuptial agreement isn't distrust. It's clarity before anger makes clarity impossible. A trust isn't about control. It's about making sure the right things happen when you're not there to enforce them. People avoid these conversations because they feel uncomfortable. Like bringing up money or death or divorce means you expect the worst. But the worst happens anyway. And when it does, the people who prepared aren't scrambling. They're not sitting in mediation rooms trying to interpret what someone probably meant. They're not hiring forensic accountants to track 15 years of transfers. They're reading documents that say exactly what happens next. I've never seen a family go to war over a well-drafted estate plan. I've never seen business partners destroy each other when the operating agreement anticipated conflict. I've never seen a divorce turn apocalyptic when financials were separated clearly from the start. The damage comes from vagueness, from "we'll figure it out later," from "let's not make this weird," from prioritizing comfort now over function later. One of the quietest destroyers is the assumption of loyalty. People think because someone is family or because you've worked together for a decade that they'll act in your interest when it counts. Sometimes they do. Often they don't. Not because they're malicious, because their interest and yours stop aligning. And when that happens, the person with documentation wins. The person who assumed loyalty loses. I've seen this in business dissolutions more than anywhere else. Two partners start a company. Equal ownership, equal effort, equal risk. 10 years later, one wants to retire. The other wants to keep going. There's no buy-sell agreement. No valuation mechanism. No process for exit. So they fight over what the company's worth. They fight over who gets to keep the name. They fight over client lists, intellectual property, staff. All of it could have been avoided with a 4-page document drafted on day one. But that would have required acknowledging that partnership might end. And no one wants to plan for failure when they're optimistic. So they don't. And years later, I get the call. The other pattern I see constantly is people signing things they don't understand because someone they trust told them it was fine. A spouse says, "Sign here." A parent says this is just a formality. A business partner says it's standard. And people sign. Then years later, they find out they guaranteed debt they didn't know existed. Or waived rights they didn't know they had. Or agreed to terms they never would have accepted if they'd read them. I can't fix that. Once it's signed, it's enforceable. I didn't read it is not a defense. I trusted them is not a defense. I thought it meant something else is not a defense. The signature is the defense. People also underestimate how much changes when children are involved. A couple divorces when the kids are young. Custody is agreed on. Support is calculated. Everything's civil. 15 years later, one parent remarries someone wealthy. The other parent's income hasn't changed. The kid wants to go to private school, or needs braces, or gets into a college that costs $70,000 a year. Suddenly, the old agreement doesn't fit. And if it wasn't written to flex, it becomes a weapon. One parent refuses to contribute more. The other can't afford it alone. The child suffers. Not because anyone's evil, because no one anticipated change. I've also seen the reverse. A parent who pays support for years, never misses a payment, stays involved. Then the child turns 18. The legal obligation ends. The relationship doesn't. But if the parent's been distant, or if the other parent spent years undermining them, the child may not stay connected. And support doesn't buy connection. Only presence does. But that's not a legal issue. That's just laws. What people don't realize is how fast things move once they start. A conversation can go from tense to litigation in 48 hours. Someone says the wrong thing. Someone feels threatened. Someone makes a unilateral decision. And the other side retains counsel. Once that happens, communication stops. Everything goes through lawyers. Every email is evidence. Every text is discoverable. The cost starts immediately. And it doesn't stop until someone runs out of money or will. Most cases settle. Not because anyone's happy. Because continued fighting costs more than the outcome is worth. But by the time they settle, the relationship is gone. You can't sit in a conference room for 2 years accusing someone of fraud or neglect or manipulation, and then go back to family dinners. It doesn't work. The litigation becomes the relationship. I've had clients win everything they wanted and still come out destroyed. Because winning meant proving their sister stole, or their father lied, or their spouse hid assets for a decade. And once that's proven, it can't be unknown. The people I remember most aren't the ones who won or lost. They're the ones who saw it coming and did nothing. The ones who told me, years into the case, that they knew something was wrong early. They felt it. They saw the signs. But they didn't want to make waves. Didn't want to seem paranoid. Didn't want to damage the relationship. So they waited. And by the time they acted, the damage was done. I don't tell people this to scare them. I tell them because it's true. The files I open next year are being created right now. In living rooms where people are avoiding hard conversations. In offices where partners aren't documenting agreements. In marriages where money is kept quiet. In families where no one wants to talk about what happens when the parent dies. Those silences have consequences. And the consequences don't wait for permission.